Please take notice on the 30th of October 2017. The foreign Indonesian fishermen who worked on the Sajo Oyang vessels Oyang 70 and Oyang 77 that Council represents in relation to a test case were taken pursuant to case number EMPC number 6/2017, bringing case against the Sajo Oyang Corporation. We will be bringing action on the 3rd of October 2017 at 10 a.m. in the Christchurch Employment Court of New Zealand, where we will be seeking an order that the plaintiffs were and are entitled to be paid sleepover pay for every hour worked performed on the foreign vessels Oyang 70 and Oyang 77 that were working in New Zealand at the times they employed my clients. This is in pursuant to Section 6 and Section 11 of the Minimum Wages Act 1983 and Section 131 of the Employment Relations Act 2000 and any other applicable legislation and regulations, and pursuant to the 2006 Code of Conduct for Foreign Fishing Crew. The plaintiffs also apply for an order that they be paid interest on the arrears amount and costs. In addition, the plaintiffs apply pursuant to Section 219 of the Employment Relations Act 2000 for an order granting an extension of time for the lodging and filing of the above application for sleepover pay, interest and costs. This is upon the grounds and in the interests of justice for the court to so order, and upon the further grounds to be appearing in the Memorandum of Counsel, and for the affidavits to be filed herein providing the evidence. This application for sleepover pay is also made upon the further grounds as follows. 1. The plaintiffs were required to be on call 24 hours per day, 7 days a week, over the whole length of each of their employment agreement contracts. 2. Being on call 24 hours a day is work within the definition of Section 6 of the Minimum Wages Act 1983. 3. The sleepovers on the Sajo Oyang vessels constituted work under the Minimum Wages Act 1983. This is because of the following factors. A. There were significant restrictions and restraints imposed on the plaintiffs as employees while on the sleepovers of the Sajo Oyang vessels. B. The plaintiffs had to be constantly available to perform their duties for the defendant on demand. C. Significant and important responsibilities were placed on the plaintiffs during the sleepover period. And D. The defendant obtained substantial benefit from having the plaintiffs be available to work 24 hours a day, 7 days a week on demand throughout the length of their contracts, which are 2-year contracts, day and night, including what should have been their rest time. 4. In short, the plaintiffs were at the defendant's disposal throughout the period of the sleepover. Accordingly, they should be paid on a 24-hour day, 7-day basis for the length of their contracts. 5. In addition to the above listed factors, the following factors are also relevant for the court's jurisdiction and consideration. A. The abject living and working conditions on the Sajo Oyang vessels, which cause the plaintiffs hardship and misery over the entire length of their contracts. B. The treatment of the Indonesian crew and the plaintiffs. The treatment of the Indonesian crew and the plaintiffs on the Oyang vessels by their employer, including the bullying and harassment that went on the vessel, which created an unpleasant environment to be in for the length of the contract. C. The security conditions imposed on the plaintiffs when they signed their contracts in Indonesia that required property such as houses and paddy fields or vehicles to be put up to guarantee the plaintiff's performance of the full contract term on the Oyang vessels, and the withholding of wages as security by the defendant and its Indonesian manning agents that caused the plaintiffs to work for the defendant under the menace of a financial penalty. D. Lack of relaxation and recreational free time. E. The misery experienced by the plaintiffs on the Oyang vessels during the abject conditions and bad treatment in combination with the security conditions, excessive working hours and little rest time that cause fatigue and exhaustion and harm their well-being. And F. The imposition of financial punishments by the defendant and its Indonesian manning agents on the plaintiffs, being 2 named plaintiffs being mine number 20 and mine number 3, who were terminated from their employment for complaining and raising personal grievances about working conditions and bad treatment, and the financial punishment of the plaintiff who resigned, mine number 18, from his employment. This caused financial hardships to those 3 plaintiffs, number 20, number 3 and number 18. And it caused the other plaintiffs to feel fear. They were afraid to resign or to be sent home by their employer. This compelled them to work in misery on the Oyang vessels, performing work under the menace of a financial penalty so as to become forced labour on the vessels whilst employed by the defendant, the Sajo Oyang Corporation. 6. The defendant was not entitled to contract out of the Minimum Wages Act 1983 or the 2006 Code of Conduct for Foreign Fishing Crews. 7. The plaintiffs performed work for the defendant over the duration of their contracts. 8. The total amount to be paid to plaintiffs for wages in respect of work performed was less than their legal entitlements under the Minimum Wages Act 1983 and the Code of Conduct 2006 for Foreign Fishing Crew. Accordingly, the requirements of the Minimum Wages Act and the 2006 Code of Conduct for Foreign Fishing Crew were not met by the defendant, the Sajo Oyang Corporation. 9. Given that sleepovers were work, the plaintiffs were entitled to be paid pursuant to the Minimum Wages Act 1983. 10. In addition, that given that the plaintiffs were foreign fishing crew, they are the citizens of the Republic of Indonesia, they were by occupation fishers, and they work for the defendant on work permits issued by the Immigration New Zealand. They were also entitled to be paid the extra additional hourly top-up rate pursuant to the Code of Conduct for Foreign Fishing Crew that applied during the whole period they were employed in New Zealand pursuant to the applicable minimum rates for the applicable time periods, and they were not paid this. 11. The plaintiffs were entitled to be paid for each hour of the sleepover and pursuant to the New Zealand Minimum Wages Act 1983 and as well as the 2006 top-up rates under the Code of Conduct for Foreign Fishing Crew. And 12. The plaintiffs were not paid for sleepovers. They make an application to apply for an order that they have their wage arrears pursuant to Section 131 of the Employment Act 2000 and the other relevant sections of that Act and other applicable legislation and regulations for sleepover work to be paid by the defendant. This application for sleepover pay is made in reliance to Sections 6 and 11 of the Minimum Wages Act 1983 and Section 131 of the Employment Relations Act 2000 and on the 2006 Code of Conduct for Foreign Fishing Crew and relies on the following cases. 1. Ideas Services Limited v Dixon, 2011 New Zealand Court of Appeal 14 at paragraphs 18 to 20. Also, Law and Others, Board of Trustees v Wilford House, 2014 New Zealand Employment Court. 3. Other relevant case law. The application for extension under Section 219 of the Employment Relations Act relies on the following cases. 1. Roberts v Commissioner of Police. 2. Prune, Praune v Environmental Decontamination Services Limited, 2012 New Zealand ERA, Christchurch, 128 at paragraphs 6, 15 and through to paragraphs 26. Number 3, Oraki Koreho, Gracelander, 2000 Resort Limited versus Unsworth, New Zealand Employment Court, Auckland, ARC 16/09, 17 December 2009, another relevant case law. This hereby gives notice that we seek these extensions and the holiday pay, as well as the top over pay rates and the sleepover pay. Thank you.